So welcome to continuation of our company law class. So we are continuing with discussion of shares, and we'll be looking at the capital maintenance doctrine and its various ramifications. So the last time we ended with discussion of composition of the stated capital of the company in terms of section 68 of Act 992. So basically, we understood the point that the stated capital of a company refers to the sum total, like putting everything together in terms of the money, which constitute what we call, if you like, the capital of the company, so to speak. And what are these monies? Monies which are realized as cash, right? As cash. From shares which have actually been issued out. And this may be in two forms: cash paid upfront or cash which will be paid later, depending upon the terms of payment arrived at the time of issuing the shares. Another money which form part of the stated capital is the money which is not cash, but then we know its money's worth or value. That is where shares are issued and other things are given, either service or other goods are given to the company as a mode of paying for the shares. And the other component is where the company decides to pass a special resolution transferring monies from its reserves to augment the stated capital. And then question arose as to what constitute the reserves of the company. So what constitute the reserve of the company include the actual, if you like, the profits which have been made. Because go to section 70, you look at the various components. You have a profit made. We call like the surplus. Okay, the surplus. So the surplus of the company, after taking care of whatever you are going to declared as your dividends and the money sitting in the company. And again, where you also have money sitting in the shell dues account, the special account which is set up for funding redemption of redeemable preference shares and all that. These are monies you can always transfer to add up or to augment the stated capital of the company. So we saw that. So we want to discuss the reduction of capital in terms of section 69, reduction of stated capital. So let me share the screen. Yeah, so we know the stated capital, and then we also know the rigid rules which have been put together in order to police and protect the stated capital from being unnecessarily depleted as it were. So you look at section 61, if you remember, we are told that the company is prevented from acquiring its own shares, because if the company were to do so, definitely it will amount to the company giving money back to the shareholders instead of having money retained in the company. But if we look at section 61, 1 subsection 6, okay, there's a provision, and I quote, before we come back to the 69, that except as provided in section 69, that is the section we are going to be discussing pretty soon, a redemption, purchase, and acquisition or forfeiture of the company by the company of the shares of the company or the cancellation of the shares so redeemed, purchase, acquired, or forfeited shall not reduce the stated capital of the company. Good. So, what constitutes reduction of the stated capital of the company? And at this stage, I want to believe that we are all clear in our mind. What is the stated capital? The stated capital is what we saw not too long ago by looking at the section 68 and all that. And we are told that, to put it simple, all monies which come to the company as a result of shares that the company has actually issued, okay, that is part of that's the stated capital. So the money is both cash and then non-cash, but we know the money equivalent. So that is stated capital. And this stated capital, as a general rule, is supposed to be conserved. And that is the heart of the capital maintenance doctrine. But section 69 is saying that despite everything that we are told in section 61, section 4, which says that on redemption, purchase, acquisition, or forfeiture, shares shall be available for reissue by the company unless a company by amendment of the constitution of the company cancels those shares. That despite this, the company stated capital shall be deemed to be reduced by the amount of money by which a redemption of redeemable preference shares is made out of the proceeds of a fresh share of issues made for the purpose of the redemption, not more than 12 months before the date of redemption. So as we learned earlier on, if you are going to redeem redeemable preference shares, you need to get money to do that, because redeeming it simply means that you are giving the shares, you are taking the shares into the company and you are giving money back to the shareholders. So the question is, where do you get the money from? The company may have some of its registered shares still unissued, right? So we have some of the authorized shares which have still not been issued. And you have redeemable preference shares which are due to be redeemed. Due to redeem means that the shareholders are entitled to have the shares returned to the company and collect their money and leave the company. But the company does not have money immediately. So what can it do? So once it had some shares which have not been issued, for the singular purpose of getting money to be able to finance or fund this redemption, it can actually issue those shares and make money. But the money made should be used for the redemption within 12 months, because the purpose of the issue of those shares is just to get money for you to finance the redemption. And that is why the law is strict, that make sure that the fresh issue you are going to do to raise money for purpose of redemption should not be more than 12 months before the date of the redemption. So let's keep that in mind. An unlimited company may reduce its stated capital by ordinary resolution. Yeah, so at this stage, we know what an unlimited company is. Unlimited company, a company where there is no liability on, there's no cap or no limit on the liability of members in terms of maybe the number of shares that they have. Unlimited company may have shares, but the is not, their liability is not subject to like the amount of shares that they have, or they may have some other arrangement for sharing a profit or contributing. And that is why Section 69(2) says that, yes, unlimited company can reduce its stated capital by ordinary resolution. So let's keep that in mind. But there's a strict procedure which must be followed before a company limited by shares can reduce its stated capital. And that is why exemption has been created for unlimited company. For limited company, it's enough for you to pass ordinary resolution. So if you look at 69(2), and you can get your stated capital reduced. But for company limited by shares, right, or any other company, so to speak, you must comply with Section 69(3). And 69(3) refers us to a very strict procedure, or very strict regime, which must be followed before you can have a valid reduction of stated capital. And that procedure is located in Section 68 to 82. So we'll be discussing a lot of 78 to 78 to 82 pretty soon. But we have discussed reserves last time when we were discussing the stated capital and all that. So we jump to this, but just to make sure that in case somebody miss out, what we are going to do is that we are going to jump to 78 and discuss up to 82. When we finish, we come back and fill in the gaps from 70 to 79. So just keep that in mind. We'll come back to it. Good. So resolutions, reducing capital, shares or liabilities, that's the part H of Act 992. And as we indicated, if you want to reduce stated capital, apart from a limited company, which is permitted under Section 69 to pass ordinary resolution and achieve that, company limited by shares must comply strictly with the regime from Section 78 to 82. And all of us should be familiar with that procedure. Very simple. So if the company wants to reduce its stated capital, it must pass resolution. And mind you, the resolution here is not ordinary resolution. It is special resolution. It is only in the case of unlimited company which is allowed to reduce its stated capital by passage of ordinary resolution. But apart from that limited instance, all other companies, if they want to reduce stated capital, they must do so by passing special resolution. And this special resolution, as 78(1), the Chapeau tells that is subject to confirmation by the court. So when you have passed a special resolution, you haven't finished the process. You need to go to court and get approval by the court before the process can complete. Now let us look at the things in respect of which you can have a special resolution. So 78(1)(a), to reduce the stated capital of the company in any way. So if you want to reduce the stated capital of the company, you need to do a special resolution and then you go to court. Or if you want to extinguish or reduce the unpaid liability on any of the shares of the company. So mind you, when we're discussing the statement of the capital maintenance doctrine as reflected in Section in 58, if you remember. Section 58, if you look at section 58, 1A, we're told that except as provided in this act, a company shall not alter the amount of money remaining payable on those shares. So 58 1A prohibited the company from changing amount of money which remain unpaid in respect of its shares. Now, section 78 1B is telling us that it is possible for the company to pass a special resolution and reduce or even extinguish, that is, remove. You either remove or you reduce the unpaid liability on any of the shares of the company. So let's keep that in mind. Now, the special resolution, which requires confirmation by court, may also relate to resolution to pay or return to shareholders any of the assets of the company which are in excess of the requirements of the company. The company may become so successful that it may get to a point that the company will say that, okay, let us reach a deal. Let's pass a resolution so that we distribute some of the assets of the company which you don't need. The company can run successfully for the next 20, 30 years without this. So let's get them back to shareholders. You need to do a special resolution and go to court to get approval before you can do that. Then a special resolution requiring confirmation of court under section 78(1) may also relate to alteration of the constitution of the company by cancelling any of the shares of the company. You can also, cancel shares of the company. So canceling shares of the company here is relate to situation where, for whatever reasons, you don't want the shares of the company to remain as it were. And mind you, the canceling the shares is not the same as altering the number of the shares. You see, it's not the same as altering the number of the shares. You are canceling the shares will presuppose that the shares have been, if you like, issued. Either there's unpaid liability or for whatever reason, there's maybe lack of there is lack of understanding or consensus or unanimity, and for whatever reason, you may need to cancel shares of certain shareholders and so on. You need the court to come in. And that is why 78(2) says that resolution relating to any of the things that we have discussed, any of the 4 scenarios under 1, is referred to as a resolution requiring confirmation by the court. So let's keep that in mind. Now, in terms of how to do special resolution, of course, we've talked about that, and we'll be discussing it again under corporate governance, except that, as we have learned, special resolution is a resolution in respect of which notice of it will have to be given ahead of the meeting in which it's going to be passed. And then when the meeting is held to, it must secure approval or endorsement by 75% of the shareholders. That is 3/4 of the shareholders, as it were. But if you are going to do any variation which will affect the right of a particular class of shareholders, then also remember discussion of the class rights and variation of class rights under section 50, you need to also comply with those specific requirements that we discussed. Otherwise, the resolution seeking to vary the rights attached to a class of shares will not be valid or effective. So let us keep that in mind. But let us also know that some of the things which have been stated under 78(1)(a) to D, okay? If you look closely at other provisions of the law, especially from section 72, for example, if you look at the section 72, we will come back and discuss what we call like the legality of dividends and so on. Now, some of the things which are stated over here could have been done in some other context. And that is what section 78(4) is telling us, that this section does not require confirmation by the court of a transaction validly effected under section 72 and 75 to 77. So where you have complied with the unique procedure provided over there, then there's no need for you to go to court and get approval, because it's the law itself which has provided that particular procedure. So let's keep that in mind. Now, if you look at the securities industry law, that is the law Act 929, we set up the Securities Exchange Commission and also allows various mutual funds and all that to be run. There are special arrangements which those type of companies will have to observe. And mind you that Act 992 is a general company law framework, and it also recognizes that certain companies which are set up for special businesses, as we saw in the beginning last semester, may be subject to other regulatory requirements. And that is exactly the same point which is being reiterated with respect to 78(5), that the things which are stated here do not work in isolation, but they work in conjunction with the special rules under Act 929, especially so if, as I said, they pertain to a company which is under the regulatory jurisdiction of the Securities and Exchange Commission under the Securities Industries Act. So let's keep that in mind. So you have passed the resolution, special resolution now, and we are told that you need to get the court order to confirm it. So how do you do that? Section 79 tells us that once the resolution is passed, the special resolution is passed, seeking to reduce the city capital or do any of the other things, you will bring application to court for an order confirming that resolution. Now, where the resolution requiring confirmation involves diminution of liability. Diminution of liability simply means that you are trying to reduce the amount of money which remains unpaid in respect of each share that have been issued, or it involves payment or return to any shareholder, or any other particular case the court may direct, then you need to comply with these additional procedures, as it were, unless the court grants you exemption from them. So what are these procedures? If the court can direct that a creditor of the company who at the date faced by the court is entitled to debt or claim, which if that debt were the commencement of the winding up of the company will be admissible in proof against the company is entitled to oppose the confirmation. Yeah, so the law actually recognizes the right of people, assuming the company were to be put on the path of winding up or liquidation, and you are entitled to make a claim against the company. Either the company is owing you, right? You are a creditor of the company, or you have some other legitimate claim against the company. Maybe your employee, your salary has been paid for a long time and so on and so forth. It's a debt which the company owes you. If the company were to actually go on winding up or liquidation, and you'll be entitled to bring a proof of claim against it, then when a resolution is passed seeking to get confirmation of the court, you are also entitled to actually approach the court and actually oppose the confirmation. You can file affidavit in opposition and tell the court that the court should not grant approval to the special resolution. Of course, we need to canvass reasons why you are inviting the court to make such an order. And the court shall settle list of creditors so entitled to oppose, and for that purpose shall ascertain as far as possible, without requiring an application from the creditor, the names of those creditors and the nature and amount of their debts or claims, and may publish notices fixing a day or days within which creditors not entered on the list are to claim to be so entered or are to be excluded from the right of opposing the confirmation. So know that the resolution which has been passed here is usually a major resolution. Major resolution in the sense that what it seeks to do, what it seeks to achieve in the company has a very far-ranging repercussions, and it may affect interests of some other shareholders. And that is why it is the law that if there are creditors who can actually demonstrate that they have sufficient interest in the company in view of the debt which the company owed them, and for that matter, they would like to invite the court to decline approval of the confirmation which the company has paid. That is it. That is legitimate. And that is why the procedure is elaborate like that. Yeah, so where the creditors entered on the list, whose debt or claim is not discharged or has not determined, does not consent to the confirmation, the court may dispense with the consent of that creditor on the company, securing payment of the debt of that creditor or claim by appropriating, as the court may, direct the following amount. 1, if the company admits the full amount of the debt or claim, although not admitting, is willing to provide for the debt or claim, then the full amount of the debt. So you have a creditor who has come forward when he became aware that an application is brought to the company for confirmation of a special resolution, either to reduce the city capital or do any other thing, which would ultimately hurt the interest of the creditor in the company by reason of what the company owes the creditor. So the creditor is not prepared to agree that the court should approve. What this provision is saying is that where the court ascertains that the company has actually admitted or confirmed that that it owes the creditor that amount of money, the court can order the company to either pay the amount of money which it has admitted it owes the creditor, or it can order the company to make some undertaking, right? Or provide security or anything to convince the court that the company will be able to pay the creditor the debt which the company owes it, so as to clear the way for the court to grant confirmation which the company is seeking with respect to the resolution that it has passed, seeking to reduce the residual capital. Now, if the company does not admit or is not willing to provide for the full amount of the debt or claim, or if the amount is contingent or is not ascertained, then amount fixed by the court after the like inquiry and adjudication, after the company were being wound up under Bodies Corporate Official Liquidation Act. Now, I'll say that in your book, or you have to cancel this because this law has been repealed now. We now have the Corporate Insolvency and Restructuring Act. So it should rather be, let me see if we get there. Okay, so this one is gone now. Let's see. Okay, this one is gone now. Let's insert the test. Insert the test. Okay, so in place of this, I think we have a corporate solvency, a restructuring, yes, restructuring Act 2020 Act 1015. So replace the Bodies Corporate Official Liquidation Act 1963 at 180 with Corporate Insolvency and Restructuring Act 2020 at 1015. Yeah, so where the company does not admit, then the court will proceed in the way that it will adjudicate any claim where procedures for liquidations are triggered under Corporate Insolvency and Restructuring Act 2020 Act 1015. So that is the point being made there. And the court may also refer the application for confirmation of the resolution to the registrar, who shall appoint one or more competent reporters to investigate the fairness of the resolution for redaction and to report on the resolution to the court. So where the court is there, the court does not have the time and then the technical business expertise regarding whether the resolution they have passed to reduce the capital, is it reflecting interests of all stakeholders, or is it injurious to interests of some stakeholders? If the answer is yes, then the court may want to be sure. So the court may want to refer to the Registrar of Companies. So Registrar of Companies, for the Registrar of Companies to appoint reporters to go into the company and examine affairs vis-a-vis the resolution to reduce the stated capital and report back to the court as whether everything is fair or there are some unfairness, in which case the court may need to make the necessary consequential remedial orders. Now, when all these things have been taken care of, then Section 80 says that the court may make an order confirming the resolution on the terms and conditions specified by the court. And so the court can make an order, yes, granting confirmation, but then there may be some other things which the court is ordering. For example, if you satisfy A with respect to every creditor of the company, who under Section 79 is entitled to oppose that the consent of the creditor has been obtained or that the debt or claim of that creditor has been discharged or secured. Or B, that Section 78 and 79 have been duly complied with, and that the resolution requiring confirmation is fair and equitable. So before the court will grant the confirmation, the court will have to make sure that all these things are actually met. And as part of the application, the minutes, don't forget that there's a special resolution. A special resolution is also actually passed at the meeting. So Section 81 says that the registrar, that is Registrar of Companies, on production of an order of the court confirming the resolution, requiring confirmation and the delivery to the registrar of a copy of the order and of a minute approved by the court showing the following. A, the new stated capital of the company. B, the number of authorized and issued shares and the classes into which they are divided. And C, the amount of money deemed to be paid and unpaid. Liability on the issued shares, distinguishing the amount paid in cash and amount paid otherwise than cash, shall register the order and minute and publish the particulars stated in the minute in the company's bulletin. Now, the company's bulletin is a special type of gazette meant only for giving the public information about incorporated companies. So where officially something relating to regulation of companies need to be communicated to the public, to the business community, to the general public, you do that through the platform of the company's bulletin. So, of course, this is also like a new addition. It wasn't part of the repeal Act 179. I mean, that will have probably made a reference to the Gazette, but now you have like a special bulletin for communicating matters which relate to governance of the company in that. So if you look at, I have my repeal at 179 close by. So if we look at Section 78, subsection 1C, it's a similar provision as Section 81, 1C, but then inside the company's bulletin we have in this new law, over the reference is made to the Gazette. I think this is better because the Gazette is being issued every now and again, so plenty, very difficult to even keep track. And this company's bulletin is for just the unique purpose of matters relating to corporate affairs and all that. So something that we can easily keep track. Yeah, so the bottom line is that when the court has actually given the approval of the resolution reducing the stated capital, that order will have to be brought to the attention of the Register of Companies. The registrar of companies also have to give in the minutes of the meeting, during which the resolution was passed. And when it is satisfied that everything is regular, then it will cause publication to be made in the company's bulletin so that everybody will be aware of the true state of affairs regarding the company concerned. Section 82 gives protection to creditors, especially creditors who Rifat, you have to go to class, eh? All right, okay. All right. Okay, so we will have to end here to enable you to have the next class. The prefect just talked to me, so we continue.